The complainant is the wife of the deceased patient, who died following major neurosurgery. The deceased was a 37-year-old employed individual who underwent surgery at a hospital. The main allegation was that the deceased did not receive proper post-operative care, which led to his death. The complainant argued that the deceased should have been shifted to the intensive care unit after surgery instead of a private room. The deceased experienced severe pain and sweating post-surgery, and there was a delay in receiving adequate medical attention. The question that arose for consideration before the Honorable Supreme Court was, when can a doctor be held liable for medical negligence? The court referred to the precedent set in Jacob Matthew v. State of Punjab, stating that medical negligence can be established if the professional either lacks the requisite skill or fails to exercise it with reasonable competence. The court emphasized that the standard for judging negligence is that of an ordinarily competent person exercising ordinary skill in the profession. It was noted that merely because a patient does not respond favorably to treatment or a surgery fails, a doctor cannot be held liable for negligence using the doctrine of res ipsa loquitur, as the doctrine can be applied only when there is clear and incriminating evidence of negligence. The court also held that the responsibility to prove medical negligence lies on the claimant, which in this case was not adequately discharged by the complainant. Therefore, the Supreme Court upheld the decision of the National Consumer Disputes Redressal Commission, which had dismissed the complaint. The court found no evidence that the heart attack suffered by the deceased was connected to the surgery or the post-operative care provided. It was also highlighted that the pain and sweating symptoms were not indicators of a cardiac issue as per the medical evidence provided. Thus, for a doctor to be held liable for medical negligence in a particular case, a medical board consisting of experts has to be constituted. This board must independently assess whether there is an element of negligence on the part of the doctor who undertook the surgery. If the medical board finds that there is a degree of negligence on the part of the doctor, then based on that finding, the court can proceed accordingly. There is also a question of whether a doctor can be arrested merely because a patient allegedly died due to medical negligence. If a police officer finds that there is an element of medical negligence on the part of the doctor, based on the facts and circumstances of the case, they cannot straightaway arrest the doctor or put them on remand. The police officer has to follow certain procedures while conducting the investigation. Primarily, the police officer has to independently assess the report prepared by the medical board constituted for this purpose, which may contain a finding about the medical negligence. If, upon further investigation, the police find that medical negligence is substantiated on the basis of the report and additional evidence collected, then they can proceed against the doctor. If you found this video helpful, please like and share it with others. Subscribe to our channel for more legal insights.